sorry. Have a Budget Finance Committee pre-meeting before the full court meeting tonight. We got 4 items on the agenda. The first one is an appropriation ordinance to provide an appropriation to 1,000 county general the elections.
Make a motion to approve.
Okay, have a motion, second. Any discussion? If not, all in favor say aye.
Aye.
Any opposed, no. Ayes carry. Motion passes. Second item on the agenda is an appropriation ordinance to provide an appropriation to pay back funds to certain elected officials. Judge, you want to address that? Or just go ahead?
Yeah, I mean, I can. This was a miscommunication between my office and the county clerk's office. When we did the raises, we didn't do a percentage raise, and so the salaries were to reflect from the first raise that was given all the way up, because we went about a minimum and a maximum. So we didn't do a percentage. So it's supposed to go a total of $20,000. But what happened is that when we talked about it and we put it in, it was at I think it was 15%. We on the spreadsheet we put in 15%, which made instead of the elected officials receiving the full 89 whatever it was supposed to be in the documentation, they were only receiving 86, and we only discovered this when we were laying out stuff for the budget as far as the raise. So we noticed that the county clerk and myself noticed that right away, and we decided we need to fix that. So the only way you can fix it is to back pay people their money, give them the money that they were supposed to deserve. So to get, so that's what that was all about.
So the main deal is just give the elected officials that didn't get their full amount of money the first of the year that get it now. Right. So well, it's just or wasn't the first of the year, was it?
What happened was when we did the budget, and so when we discovered that, so that means that they didn't get the full amount of pay from 2022, and then from January up until August of this year. So it affected everyone, and then also 2 people that's no longer here, which was Barbara Collins and Yvonne Humphrey. And then for the elected officials that's in those positions now, which is Gloria Tillman and Flora Bishop Cook. Flora Cook Bishop. So that affected them from January up until now. And then for the year of 2022, it affected Ms. Collins and Ms. Humphrey. So we figured that amount up, and I don't have it right here readily available. But I think it was like $30,000. Yeah. Yeah, 30. I can't see it. 30,000.
30,494 and 63 cents.
Yeah, would make the difference, and that would bring, that would give them the back pay and the pay that they were supposed to get.
So it's just catching up on the money that they didn't get.
That they didn't get. Yes.
So what is your pleasure? Got a motion, second. Any more discussion?
Mr. Chair, if I may ask, I guess when this particular ordinance or whatever it was passed, I wasn't a member of the Quorum Court, but what I am trying to find out, is there any documentation, anything to substantiate the difference between the 20,000 or the 20%? Is there anything in writing that references that where the Quorum Court approved it? Because basically right now what we're going off of is just the word of the county judge.
I believe there's an attachment. If you read that, it details who gets what when.
Well, I understand that, but that attachment was dated for August 4th, 2023. I'm saying, is there any documentation, anything to rely upon when the actual change was made? I mean, it's kind of like saying, if you're talking about 20,000 to 20%, you could change and say 20% versus 30,000. What I'm asking is there an ordinance or something to substantiate what he is claiming, documentation? If it was passed by the Quorum Court, there should be some type of documentation or something to show that this was something that was agreed upon by the Quorum Court or something on file stating that this is the particular raise that they should incur. After all, the Quorum Court does set the slot amount, so were there not any slot amounts or anything attached to the actual raises that were given, or no type of documentation where we can rely back on or go back and look at and say, hey, this is what it's supposed to be? Because right now, all we have is one person's word, which I'm not questioning his word right now. What I'm saying is that I wasn't here when it was passed, and I just need some type of documentation to substantiate the claim.
Okay, Judge, I'll let you address that if you'd like.
Is this just,
Hold on,
are we talking?
hold on, I've recognized the judge first,
Okay.
then I'll come to you.
Yeah, it was in the minutes of the budget meeting itself. And again, so if you go back and you look at the records, it's in there. It's in the records. But the thing is that, no, we did not pull the ordinance, but it is in, and some of the Quorum Court members that were here remembers, because I think it was Justice Carroll that asked if we were doing it by percentage, and I advised him, say, no, it's not by percentage, we're going by the minimum and the maximum, and we didn't put a percentage on it. And so it's supposed to reflect a total of $20,000 between the two raises. The first one was 8%, and then when we did the next one, it was to raise it up to where it would reflect the $20,000 raise total. Because if you remember, the employees got two raises, but on the second, when we did the second raise for the elected officials, again, we didn't attach a percentage with it. We just wanted to equal up to a total of 20,000. And so some of you may remember when we made that statement in one of the Quorum Court members, one of the Quorum Court meetings, and I asked about it, and they explained then that they didn't get a $20,000 raise, but again, when we went back and we looked at this, because it was from the meeting and what we raised it up to that it was supposed to be, but again, did not detect it until we were looking at the salaries. So it's in the minutes, Justice Franklin, if you want to go back and look at the 2021 minutes, it will reflect of what we raised the elected officials up to. So we can provide that to you at a later date, but now I'm just going to be honest with you. As you taking, I'm sitting here speaking it, but now as frugal as I try to be with the money, I brought this to the head because I would not want to be the one shorting any one of their money. And if you may notice, well, Justice Franklin, you weren't here, but the same thing occurred when the justices of the peace, when I said that they were getting the maximum and they weren't. And I went back and I made that correction. And so I think it's, I always try to, make sure that we're on the right track and doing what we're supposed to do. And when you find a mistake, you need to correct it. So that's what we did.
Thank you, Judge. Justice Holcomb, do you have anything?
Yeah, I was just pretty much what the judge said. I think we're just trying to correct an error that was made in the way that we carried that out.
Okay. We've had a motion and a second, so any further discussion?
Chair.
Justice Carroll.
Yes, sir. I heard the judge reference me as to, yes, this did happen. And I don't know that I said those things that were contributed to me. But let me say this. I don't understand how in that budget, and the judge, you almost alluded to it, that you put forth, there was a 20% raise for elected officials that was omitted, but yet there was an 18% decrease in the per diem compensation of justices of the peace. And there was no conversation relative to that, and that was within that budget that none of us discussed and had anything to do with in its formulation. So I don't understand how you being frugal with the money and setting salaries, which the Quorum Court is supposed to do that somehow the elected officials in this very crucial time of trying to put together procedural ordinances, that we find that, oh, we didn't give you our 20% of your money, but at the same time, it has been enacted that each justice of the peace lost 18% of their per diem compensation. I don't understand how we miss one but cut the other. I don't understand that. And I don't take credit for having asked that question I was given credit for, but I would like to see the minutes of this particular action.
If I may,
Go ahead, George.
the reduction of the justices of the peace pay came because we went from a class 6 to class 5. That's statutory. That had nothing to do with whether the judge wanted to do it or not. That was a salary that was set by the state of Arkansas regarding a class 5 and a class 6. So we didn't have a choice in that matter.
I think you're incorrect there.
Well,
Not the
that's,
county size, but the amount of per diem compensation. Because the per diem compensation for justice of the peace in a classified 5 county is even more than what the justices were receiving previously. I think if you check that, and if anyone else checks that, you'll see that it's more than what the justices were making in 2022 and 21.
again, Justice Carroll, we received those numbers from the Arkansas Association of Counties, and we checked that. And I think my office and also the clerk's office did our due diligence in checking what those per diems were, and we adjusted accordingly. Now, as far as the elected officials' salaries, I did not or would not even attempt to set the salaries. We present it to the Quorum Court, and the Quorum Courts vote on those. That's certainly within their purview to do so. We have a minimum and a maximum. Each county, whether it be whatever class it is, has a minimum and a maximum. And so you have a salary range. Jefferson County sits somewhere between in the range of 75% of the minimum and maximum range for their particular salary. So the salaries that were voted on and granted were well within those parameters. And so that was done and presented to the Quorum Court, and it was voted on. Now, certainly, if the justices wanted to question that, the amount of whatever, again, we can go back in the minutes and show that, but I would not bring anything to the attention of the, to this court. And regardless of what we're dealing with or whatever, my statement is simply this, is that the salaries were supposed to be up to the amount of $20,000 more than what they initially made. There was some discussion about that in that Quorum Court in the budget meeting, and it was agreed upon. It was discovered that it was less than that, and this is simply to back pay the elected officials. This is not to make anybody feel good. We're just trying to make right what was done wrong, whether it was my mistake, a combination of both officers' mistake, it does not matter. These individuals were supposed to make a certain amount, and it's not happening. And they need to be paid.
Thank you, Judge. I think it clarifies what the issue is. If there's any discrepancy with the JP salary, we can address that later. You might want to visit with the judge at a separate time about that, and he can show you the documents on that as to what our salary. It's not a salary, it's a per diem, so that we receive. But we have a motion and a second. All in favor say aye. Aye. Any opposed, no.
No.
Okay, you want to call roll, Judge, or we just got one dissent?
AG,
Yes.
Adams. Adams. Justice Adams, we need you. It's your turn.
I said come back. No.
Byrd,
Yes.
Carroll,
No.
Dumas,
Yes.
Gaddy,
Yes.
Harden,
Yes.
Holcomb,
Yes.
Jackson,
Yes.
Patricia Roy Johnson,
Yeah.
Reginald Johnson,
Yeah.
Marguerite Williams,
Yes.
Justice Franklin,
Abstain.
passes 9-4, and 2 against and 1 abstain.
Mr. Chair, if you would.
Mr. Judge, I voted, I should not have voted as chair, but, so it still passed. Right.
Mr. Chair.
Okay.
If you would, for clarification, point of clarity, could you please ask the county judge, and I believe I heard him right, he said that when the JP's salary was changed, that he presented it to them. I'm just looking for a little clarification on it. I just kind of found that kind of hard, that if he presented their salaries to them for the change, they voted for their own reduction without any proof from what Justice Carroll is saying, so.
Okay, Justice Franklin, this is a different issue than what's on the agenda tonight. I was here and we all were aware of what our salaries are not. We don't have a salary, it's a per diem. If we miss a meeting, we can only miss one, and then we don't get a per diem. But anyway, so this motion is passed, and that'd be something that get brought up at a later date. Okay, item number 3 is an appropriation ordinance authorizing a one-time lump sum payment to the circuit clerk for accumulated unused leave time. And that's $2,499.20, which is the maximum she can receive by law. Okay, we have a motion second. Any discussion?
Mr. Chair, speaking
Yes.
to that item number 3, I think you probably need to scratch that one from the agenda. It's actually already listed on the full Quorum Court's agenda. So there's no point in passing it back through committee, something that's already at the Quorum Court level.
Well, it's on here now, so it's futile whether it is or not, so we'll go ahead with it. So all in favor say aye. Any opposed, no.
Mr. Chairman, point of order.
Any opposed, no.
Point of order.
We're voting. Any opposed, no.
There's still discussion. You got to give him a chance to discuss it.
There-
You
you've
may
already
not
dis-
like it. He has a comment. You can't not hear
I
what he
called
has
for
to
the
say.
vote already. You can discuss it later. Let's get the vote and then you can discuss it.
Do we even know what we're voting on?
We just said the unused leave time for the lady, the
Listen,
floor cook,
there
bishop,
needs to be-
to receive her $2,499.20.
Justice Harden. And I'm being civil. I'm trying to be very civil with you. Listen, we've only heard your comment, and that's fine. We understand where you sit with it and where you are with it. But what I'm asking you is please don't silence the rest of the JPs from their comments concerning this matter. So since you seem adamant on us voting on it while it's in committee, and I'm telling you that it's already on the full Quorum Court's agenda, under this stage of where it is, what that amount is, I am not in agreement with that. And so if we're not going to adjust it to what it needs to be, then it needs to be killed.
Well, then are you making a motion that we scratch this off the agenda?
You know what, I tell you what I'll do, because it's already on the other one, just to be on the safe side, I make a motion to table it to the next committee meeting.
Well, this is on the full court meeting.
Not
So-
by whose agenda?
Well, you just said it.
It's on here under unfinished business from last month, the items we
Okay,
must
so it's
handle from
already on
last
there.
month.
So
Right,
we'll
so-
discuss that at the full court meeting.
Okay, all right.
Okay, so all in favor of, from this committee, we have a motion and second. All in favor, say aye. Any opposed, no.
No.
Okay, we have 2 noes, and the rest, it passes.
So there's no roll call on that one?
Judge, you want to call
No
roll?
vote, Mr. Chairman.
Judge, you want to call roll
Mr.
on it?
Chairman, may I speak to my no vote?
Justice Carroll, I don't think we need to discuss it anymore. Let's have the roll call. Let's have the roll call. I'm talking. Let's have the roll call and see who votes what, and see if there's worth
May I speak to my
anything.
no vote?
Well, we're going to get you to you.
May I speak to my no vote?
AG,
Yes.
Adams,
No.
Byrd,
Yes.
Carroll,
No.
Dumas,
No.
Gaddy,
No.
Harden,
Yes.
Holcomb,
Yes.
Wait a minute, Judge, I'm not a voter unless it's a tie.
Jackson. No. Johnson, Patricia Johnson.
Yeah.
Reginald Johnson,
No.
Marguerite Williams,
No.
Justice Franklin.
No.
Okay, the motion fails.
Yeah.
Judge, so we do not have this. If it's on the full court agenda, we'll address it at that time. Okay, item number 4, be it resolved by the Quorum Court of the County of Jefferson, State of Arkansas, that a resolution authorizing county judge of Jefferson County to apply for a grant on behalf of the Jefferson County Circuit Clerk. What's your pleasure? Okay, I have a motion second. Any discussion? If not, all in favor? Any opposed?
No.
Okay, we have 1 no. Do we need a roll call?
That's what you've been doing.
You give us a roll call? Yeah, put it on the record.
AG,
Yes.
Adams,
Yes.
Byrd, Carroll,
No.
Dumas,
Yes.
Gaddy,
Yes.
Harden,
Yes, I'm not voting, Judge.
Holcomb,
Yes.
Jackson. Yes. Johnson,
Yeah.
Reginald Johnson,
Yes.
Marguerite Williams,
Yes.
Franklin,
Yes.
passes.
Okay, motion passes. This concludes the Finance and Budget and Finance Committee. We're adjourned.
Judge, may I ask you a question? Information, please.
Justice Carroll,
The meeting that was just held, is this a special call, agenda for a court meeting, or was it, committee meeting? The caption on the top of the sheet says,
okay. Committee,
special court meeting.
should have been committee meeting.
So it's not a special.
This is the Quorum Court meeting for Monday, August 7th. Here at the Courthouse, 101 West Barricade. Pastor Barnes was supposed to be here to do prayer. I see he's not.
Judge,
Justice Carroll, would you lead us in a word of prayer, please?
there was a prayer.
Yes.
Father God, we heavenly come before you this evening, seeking your blessings and asking your guidance. Oh Lord, we're so grateful, so thankful to have this opportunity to serve you as we serve your people. We pray, oh God, that you will strengthen us, give us courage, give us the capacity to do what's right. We ask that you bless our actions tonight. Bless Jefferson County. Be with the family of our lost, deceased deputy, dear Heavenly Father, be with that family. Let them know that they're not alone. Let that department know, Lord God, I appreciate it. us of our sins and our transgressions. It's in Jesus' name.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good. Can I speak, please?
Justice Carroll.
Judge, in keeping with the procedural ordinance that I believe prosecuting attorney said it was legal and binding until such a time as it comes before a magistrate to declare it not so. Under that provision, a agenda was prepared and sent out by the clerk's office for this meeting. There's also a second agenda here that I'm assuming came from someone else or some other entity. And it seems to be the agenda that's on the screen. Judge, that agenda is not the agenda that was submitted by the clerk's office in keeping with the procedure ordinance. And I would say it's out of order for us to proceed with that particular agenda because it did not come out of the clerk's office in keeping with the procedural ordinance. And if I need to make it into a motion, I will.
Thank you, Justice Carroll. That's, yeah, your statement is noted. We're going to move on, Madam, with the treasurer's report.
I'd like to make a motion, Judge.
Okay, I'm sorry. Roll call. Madam Secretary, would you call the roll?
I'd like to make a motion, Judge.
Justice Carroll. Madam Secretary, call the roll.
Adams.
Here.
Agee. Byrd. Curl.
Here.
Dumas. Franklin. Gaddy. Hardin.
Yes.
Holcomb.
Here.
Jackson. Patricia Johnson. Reginald Johnson. Margaret Williams.
Thank you. Next, we'll have the treasurer's report.
Good evening. Good
Evening.
I will be reporting for the month of July 2023. We had a beginning balance on July 1, $221,977.73. We had total revenue of $13,425,084.89. Expenditures for the month of July total $14,566,142.49, which gave us an ending balance on July 31st, $24,080,920.13. I also prepared for you guys 2024 revenue estimates, and it should have been on your at your station at committee meetings last week. My door is open if you have any questions about either the treasurer's reports or the revenue estimates. Please feel free to contact me.
Thank you.
This time, point of order, County Judge. Before we proceed,
Justice Franklin, you hadn't been recognized.
point of order. I'll wait.
Okay. Are you finished with your report? You have any questions of the?
Question for you. Point of order. Clarification's sake, we need to address this with the agenda that we're using going forward. There's two different agendas, and I know you want to just blow through it because you're the presiding officer. But we are in disagreement with you on this agenda, and there needs to be a discussion on proceeding with which agenda we're proceeding forward with.
We will be proceeding with the agenda that came out of my office. I am the presiding officer of the court, of the Quorum Court. And so to answer your question, in short, we will be proceeding with the ordinance that came out of my office and what you see on the screen.
Yeah, at that point, we're going to have to confer with the county attorney.
Justice Franklin.
Judge Robinson.
Justice
At this
Franklin.
point, we will confer with legal counsel Just because you're the presiding officer does not mean you control the quorum court.
Justice Frank,
We will
if you have a
confer
question-
with counsel. I have a question for counsel. No, I have a question for prosecuting attorney Kyle Hunter.
The county
Counsel.
attorney,
Counsel.
the,
Counsel.
does
Do
he
you have a problem with
represent,
it?
does he represent you?
He represents Jefferson County.
He,
You have a problem with me directing a question to him? He represents Jefferson
yes, I
County.
do. The county attorney is,
2003-5, the prosecuting attorney shall serve as the county attorney until another attorney is
Well, Justice-
named that by
Justice,
ordinance. Either way,
Justice Franklin, I
I
think you
have a
better go back
question
and
for
check.
him.
I think you
and
better go back and check.
I don't
because
need to
you'll
go
find-
back and check. I'm about to check right now.
Okay,
So are you going to allow me to check, or are you going to obstruct it and bully your way through this one too? I have a question for counsel.
You are out of order.
No, I'm not out of order. I'm pertaining to the law. I have a question, so
submit
are
your-
you going
submit
to
your-
allow the
submit
question?
your
No, we're
question.
not submitting nothing in
Submit
writing.
your question in writing.
We're going
and then
to
we'll
ask
get
a
back with
question
you.
right
Ladies
now.
and gentlemen, we're going to move on.
No, we're not gonna move
Yes,
on.
we are. We're going to move on.
We're not going to move on.
We're going to go with the report of the committees.
We got another point of order. Judge Robinson.
I have a question. Since we did vote on another procedure ordinance, is it legal for us to go by this? Per your attorney.
Well, you said you voted on a procedural ordinance. We believe that your procedural ordinance is not valid, and I believe that your procedural ordinance is out. That's why the lawsuit was filed, and we're going to go by this agenda. And if you guys do not like it, that is just the way it is. I'm the presiding officer, the county judge, the chief executive officer of the county. And so we're going to move on to the reading and the disposition of the minutes.
I make a
Madam
motion that we, I make a motion, we didn't ask you to entertain it. I make a motion,
Secretary, would
I
you-
make a motion,
Go with
I
the
make a
disposition of the
motion,
minutes?
no,
Okay.
Point of information, Judge, may I ask you a question? May I ask you a question, please?
Justice Carey?
Yes, sir. Did you not, in a previous quorum court meeting, indicate that you were going to go with the prosecuting attorneys to see, I think you leaned over to your
No, I did
right
not.
and said, oh,
No, I did not.
so let me finish the question.
Finish your question.
Okay. Did you not indicate, that you were going to go with the prosecuting attorney's ruling on the legitimacy of the procedural ordinance that was passed by 8 of the quorum court members? And we went on and transacted business that you later, took a different, you didn't say that?
No, I did not. As a matter of fact, I told you that your meeting was illegal. I did not agree with your meeting, and I still feel that same way. No, I did not.
No, you
To
walked
make
out of that.
it, no, I did not, to make it short. So I'm not going back and forth.
Right.
We're going, we're going to,
Just sit there and use the bullet pulpit to railroad your way through county business over the quorum court.
This is
over
not-
the citizens of this community,
this
nobody
is-
say nothing.
this is not a railroad, Justice
What do you
Carroll.
call it then?
Justice Carroll, the same,
You put
some of the
items
same
on the
people,
agenda
some of the
that
same
you
people that
thought
elected
quorum court
you.
members would be favorable to, so that it would allow you to go ahead and railroad your way through this procedural ordinance. You are using the county officials to try to influence the justices so they will vote on items that you know you have put forth inappropriately. And that's a sham, talking about you, as close as you say you watch the money, that you made a mistake with salaries to the point that you're coming back now in the midst of this heated debate about procedural ordinance and putting forth, and you're manipulating everybody on this court to vote to pass it so you can have your way. And unfortunately, I'm gonna vote against all of it, I'm sorry.
well,
Justice
we're
Carroll,
not
that's-
going to
Justice Carroll, that's your right. That's your right to do so.
Point of order, Judge, at this particular time, I still need to redirect my question to counsel. So at this point, what I'm asking you now is, are you going to deny this quorum court access to legal counsel during this meeting where we're passing legislation? where we have always been able to have access to counsel during the meeting. At this particular time, for the first time in Jefferson County history, are you denying the quorum court access to counsel? Is that what we're doing today, sir? That's a yes or no question.
Really? You're the county, you're presiding
I'm a
officer?
quorum court member. You told me to stay in my lane, remember?
Yes.
That's what you said. So we're trying to direct a question to counsel. You don't vote here. You do not have a vote here. You're not about to push us into doing some illegal actions as you have in the past. We're asking to confer with counsel. Are you denying us that right? You don't have a vote here. You're just officiating. You're a referee. You call balls and strikes. You're not even to engage in debate. Balls and strikes, recognized motions, parliamentary procedure. No, we're calling it what it is. So I'm asking you, are you going to let us speak with counsel?
Judge, our legal counsel is.
Just as hard, you don't have the floor.
I don't care.
Are you finished?
Yes.
We have a lot of people, we're talking about disrespect. We're talking about people don't want to hear what's being done or said. We haven't had decorum in this quorum court. Constitutional officers, people that's elected by the people. We sit here and we talk about our society and what's happening in our community. It's no wonder the things that are happening because we're certainly not the example.
Order.
You're debating. You're debating.
I am talking.
You're debating.
I am talking.
You're debating.
And you, well, Justice Carroll, I guess you're gonna.
We're at that point.
Sit
We're
there.
at a disagreement. We don't agree
And
with you.
that's
We want a
exactly-
second
and
opinion.
that's-
You're
and
trying
that's-
to control
and
the
that's
quorum court
exactly
meeting,
what it is.
and you're
It's a
wrong.
disagreement.
You're being a dictator right now. That's what you're doing.
What is a dictator?
You're being a dictator. It's got a picture of you right beside it in the dictionary. Dictator, Gerald Robinson.
Well,
And
apparently-
you smiling at that.
And apparently you don't know what a dictator is. You want me to read you the definition
listen,
of a dictator?
we are asking to speak with counsel. We didn't ask for the
Justice-
whole
Justice-
paragraph or synopsis, whatever you're offering.
Justice-
Are you going to allow us to
Justice
speak
Holder.
with counsel?
Do you have a question?
Yes, I understand that we need to do things in proper order, but it's my understanding that this whole thing that we're discussing is under litigation right now. And a judge is, I mean, the prosecuting attorney and anyone else can have their opinion, but their opinion is no different than anyone else's opinion. There's a judge that's going to have to make a final ruling on what's taking place before we actually make a decision on actually where this moves forward from this point, as far as I'm concerned.
So with that being said, what gives Judge Robinson the right to overrule the voting body of
I don't
Jefferson
think you
County?
even had the floor, sir.
The question still stands. Are we going to get to direct the counsel?
You just like to talk.
I just got a question to ask the council. Are we going to get to ask the council? I mean, any other time, any other meeting, we have a question for the attorney, we can ask the question to the attorney. I have a question for the attorney. If I can't answer it, there's probably 8 or 9 other people here that want to ask the same question to the attorney. Why are you denying us the right to speak to counsel? If you don't agree with us, that's fine. What's been passed is the law. You don't have the right to override the quorum court. You asked us to stay in our lane, you need to stay in your lane. We pass legislation. You referee the meetings, balls and strikes, motions, that's what you observe. We're trying to speak with counsel and you're trying to deny us that. You don't have not one good reason to keep us from talking to an attorney. Do you think that somehow somebody sprinkled some magic dust on the prosecuting attorney having to come in here and lie for the quorum court? You think he's gonna put his reputation at stake when he comes in here and says he's an attorney? Are you an attorney? You may not agree with us, but are you an attorney?
His opinion. It's his opinion.
And if we disagree, what gives you the authority to override the majority of the body of this legislative body? If we're in disagreement, you can't vote. We vote. So if we vote for what agenda we want, who are you to stop us?
Are you finished?
Can I speak to
If you're going to address the question.
Are you finished? Justice Harden, you have anything to say?
I would not mind letting just our county attorney Wynn state his opinion whether or not this is legal or not.
My question is directed to prosecuting attorney
Our county
Cal Hunter.
attorney is
No.
Terry Wynn. Just
Well, look, if this is, if this gonna move, I will allow justice, I will allow the prosecutor to speak, but noted that he is not the county attorney, but he is allowed to speak.
Okay. You know, again, Mr. Wynn and I are not in a battle over who's the county attorney. But my opinion is that when that ordinance got passed, that it, on its face, appears to be a valid ordinance. And it is until such time as some court says that it's not. Now, that's my opinion. I'm not a judge, so I can't tell Judge Robinson what to do, wouldn't even pretend to. I'm assuming that probably Terry Wynn has a different opinion than I do about that issue. But that's my opinion, is that that you passed an ordinance, a procedural ordinance, you've been trying to do it since January, you passed one, and then it's valid until a judge says it's not. That's my opinion.
Thank you. Justice A.G.
I'll tell you what I'm gonna do. I'm gonna go along with what we've been doing as long as this under litigation. And everybody better really think about it until this thing gets in court and gets decided and see which way it's gonna go. If that judge ruled that thing is valid and we need to adhere to that, I'm 100% for it. But I'm not gonna change the way I'm doing anything until litigation is over, since it has been filed. That's just me. That's my opinion. I think we probably really all stick by it.
Well, at this point, I make a motion that we proceed the rest of the meeting. It's still a motion. I make a motion that we proceed the rest of the meeting with the agenda that came out of the county clerk's office. We got a motion and it's properly second. It's a motion and properly second. It's been second, so that means there's a vote. You don't have the authority to override a motion that's been properly motioned and second.
We're gonna move on. You got an opinion from the attorney. I preside over this meeting.
How about this one? I make a motion to adjourn. I make a motion to adjourn. A motion to adjourn. You're not gonna hijack the meeting.
You're not gonna hijack the
You're not right. You're not right. The whole county is watching you. You're not right in what you're doing. You're just illegal. You just bulldozing through it, and you just to heck with the law and everything.
Madam Secretary, would you please read the disposition of the meeting, of the minute? We're gonna move on.
The Jefferson County Quorum Court met for its regular meeting at 5:30 p.m. Monday, July 17th. Justice Reginald Adams gave the invocation. Judge Gerald Robinson called the meeting to order. Judge Robinson asked everyone to cite the Pledge of Allegiance to the flag. Chandra Taggart, County Clerk, called the roll. Following members answered present upon the calling of their names: Reginald Adams, Roy Agee, Conley Byrd, Alfred Carroll, Melanie Dumas, Lloyd Franklin, Brenda Gaddy, Ted Harden, Danny Holcomb, Cedric Jackson, Patricia Johnson, and Reginald Johnson, and Margaret Williams.
Judge, I move we approve the minutes as was handed out to us instead of having to read it all.
Second.
Motion has been made and properly second. All in favor, respond by saying aye.
Aye.
All opposed, like sign.
Aye.
Madam Secretary, call the roll.
Adams. To approve the minutes, as written.
Yes.
Agee. Byrd. Carroll.
Am I voting, I'm voting against that motion, so am I voting no, or I'm still voting yea?
No, if you.
Voting no. I'm voting no.
Dumas. Franklin.
No.
Gaddy. Hardin.
Yes.
Holcomb.
Yes.
Jackson.
Yes.
Patricia Johnson. Reginald Johnson. Margaret Williams.
Yes.
It passed.
Next, we'll have a report of the committees, starting with Human Resource Committee of Justice Danny Hope.
I think we got too many things lit up. Everybody needs to mute their microphone.
Turn your
Microphone. Wouldn't let me light up. I had one item on the agenda and it failed to pass due to to no motion, so it failed in committee.
Next, we'll have the Public Safety, and that's Justice Roy A.G.
Yeah, we had 3 items on the agenda. They all was, moved on to, Quorum with the big bag.
Okay, thank you, Justice A.G. Next, we'll have Budget and Finance, that's Justice Ted Hart.
Justice Judge, we had 4 items on the agenda, three passed on to the full court from our committee and 1 failed.
Okay, the ones that was passed, the ones that was passed previously in the committee. So you had those 3 and how many?
We had 4.
Okay. All right.
3 passed and 1 failed.
Okay. Next, we'll move on. Any comments or questions from the public on the business before us? Being that there's none, we'll move into new business.
Judge, I move that we read the ordinances by title only and move the 3rd reading where applicable.
Point of order, Judge.
We got a motion.
There's a motion on the floor.
What was the motion? If I got a second.
That we read the ordinances by title only and move to the 3rd reading where applicable. If it requires 3 readings, I move that we suspend that rule as well to read it 1 time.
Judge, do I speak to the motion? Did you get a second?
Yes, we got a second.
Do I speak to the motion?
Is that, yeah, you can speak to the motion. Go ahead.
I'm going to encourage our court members to vote against this continued misuse of that statute to not read these ordinances by in their entirety by 1 time. At some point in time, the Quorum Court is going to have to itself go by the law, even if it costs us more time. To continually come here after we know we're not supposed to do it and continue to do it. I just hope and wish that you would not support that motion to read by title.
Judge, can I speak to that? We get the packet.
Justice Harden, go ahead.
We get the packet. Everybody should read the ordinances before they come to the meeting. That's why, to save time, we read them by title only, which takes up enough time anyway. And if we've done what we should have done, we've read all the ordinances, and if we have any questions, we can ask them at that time. So I don't see what the problem is, but that's my question. That's my point.
I refer to the county attorney. Would you please stand in?
The law clearly allows this group to move any ordinance up to the 3rd reading and read by title only. It's not required to do complete reading at any stage. I can give you the site to that if you follow it with the law.
May I speak, Judge?
Justice Carroll.
I want to debate the attorney on that fact that the Constitution allows the Quorum Court to maneuver how it chooses. But I would also, the statute that the attorney just quoted does lay out in the plan for items to be read in their entirety. And the only reason we suspend the rules is because we're going against the rules. You don't suspend the rules if you follow the rules. You suspend the rules to do opposite of what the rules tell you should do. So yeah, the law is permissible in its application, but the statute is there, and we have to take an action to suspend suspend the rules to keep from going by the rules. And that's the only point I'm making, that when you suspend the rules, you're not going by the rules. And yes, the law does allow us to do that.
Okay, point noted. Madam Secretary, we have a motion and a second. Any other discussion?
Yeah, I have some discussion.
Justice Franklin?
Let me say this. Going forward, all ordinances need to be read once in their entirety for transparency purposes. There's been instances on this quorum court where justices have voted for an ordinance that has been changed right under their nose. So going forward, I'm only supporting reading the ordinances at least once in their entirety. Now, staying in my lane as a quorum court member, and I'm looking at this agenda, I'm going by Arkansas law, and I'm pretty sure both attorneys over there will agree. Last meeting, we passed a whole lot of stuff under a vote that was not proper. The judge exercised his power to veto. That veto, or whatever motions or considerations the quorum court chooses to take after that veto, must be addressed at the next immediate meeting. That is Arkansas state law. And as I look at this agenda, it does not have a place for that as we proceed with this. It should have been handled under unfinished business. We're in new business. There's 3 or 4 items on here that we're about to pass, and there's no mention of the veto that occurred last month, or how we deal with it, or the items that were vetoed, which must be addressed and dealt with. So are we going to continue breaking the law, or do either one of the attorneys want to step in and say, yes, this is state law, it's statutory, we must deal with the veto that was rendered by the county judge, or are we just going to ignore that and move on too?
Okay. The court recognizes Attorney Nguyen.
Yes, I looked into it. The problem you all created was you passed a number of ordinances without reading even the title.
Point. Agreed.
Okay. So if judge vetoed them because of that, if you override his veto, you've got ordinances that are inappropriate because you did not read anything, even the title.
Agreed.
All you're doing is reinstating an act that was in violation of the law.
However, and I don't mean to cut you off because I'm in total agreement with you. But however,
Let him finish.
if we chose to take action on the veto and made a motion to apply all of those ordinances to this agenda, to reread them with Ted suspending the rules individually, are we not allowed to do that to address the situation of the items, the 20 or however many items it was that we passed?
You can't do that. All you're doing is voting to override the veto. You're not presenting, you can certainly present ordinances, but you've got to present them. You can't just say, okay, we're going to veto something that happened and that reinstitutes what we were trying to do. It doesn't do that.
What I'm asking is, can they be added to the agenda tonight to be reread properly?
Well, you don't have them, is the problem.
Well, they're on the agenda. They were on the original agenda that came out of the clerk's office to deal with them before it was hijacked by the county judge.
Nobody has copies of them. I couldn't find copies.
We already read them. They were in the
When you
emails.
introduce something, it's got to be filed.
And there were not copies attached to those, that agenda that was sent out by the clerk's office did not have the actual ordinances with them. For the ones that were sent out by the county judge's office does have the ordinances with
So
them.
you're saying
They did it by title only, and that,
you never got
Sorry.
the, you never got the ordinances?
Going beyond. So the veto is being discussed.
No, actually, we're still on the motion. I just brought up the veto.
Okay, the motion was, motion on the floor and a second. Any other discussion?
this is item number 1, dude.
Yes.
Could you please restate the motion?
Title only.
Yeah, the motion was, to suspend the rules and read by title only.
Tell you what. I got a second. I make a substitute motion. Madam Chair, I make a substitute motion that we just suspend the second and third readings and read the ordinances in their entirety.
take my second.
That's just ludicrous.
Oh, you just want to?
So we taking a roll call vote on the first motion that was made. So we gotta handle the first one before we can go to the second.
Substitute motion, read all the ordinances on the agenda, these here in their entirety, suspending the second and third reading. So that means we read it one time in its entirety for transparency's sake for the public, and we're suspending the second and third reading. So the vote tonight will be the final vote on these items before us.
Sir.
For clarity's sake, reading it in its entirety and moving it to the third reading. And the full reading will be the third reading, which will be tonight.
Okay, so this is the roll call vote for the substitute motion. Adams,
To read it in entirety and skip the third reading.
Well, moving it to a third reading. This will be the third reading. We're skipping the first and second and moving to the third.
Ordinances and attachments. Yes.
No, just the ordinance. Just the ordinance.
Just the ordinance, the title,
Okay.
just the title.
Yes.
Agee,
No.
Byrd. No. Carroll,
Yes.
Dumas. Franklin.
Yes.
Gaddy,
Yes.
Hardin,
No.
Holcomb.
What do we vote now?
The substitute motion to read in it.
The whole ordinance.
No.
Jackson. Patricia Johnson. Reginald Johnson. Margaret Williams.
I need to abstain because I have a question, and I know this is not the right place for it.
1, 2, 3, 4, 5, 6. So you got 6, 5 noes, 1 abstain, and 1, 2, 3, 4, 5, 6, 7 yes. It
Okay, I
passed.
have a question on that.
Yes, they're in there. It's in their packets. It's in their packets.
So, question, like when the other 25, 26 come up, they all need to be read in their entirety at least once.
That's correct.
That's where I was trying to get a handle on before I answered.
Okay, did she vote?
Stop saying.
I'm sorry. Okay.
So we're on item number 1, an appropriation ordinance to provide,
First, you have to actually go back and vote that that was submitted as an amendment or a substitute.
okay,
You have to actually vote on it as a motion.
making that one okay. Okay, this is the vote to make it the original motion now. Adams? Agee? He said it's just going back and doing the original.
Okay. Go ahead. We're in the vote. We stand by.
The amendment was voted.
Agee? He stepped
He's
out.
in the bathroom.
Bird? Carroll?
No, this passed.
Will you state the motion, please?
This is to read it in its entirety once, moving to the, okay. Dumas? Franklin?
Yes.
Gaddy?
Yes.
Hardin?
Yes.
Holcomb?
No.
Jackson? Patricia Johnson? Reginald
I
Johnson?
think y'all confused.
My vote, I misread it. No.
Okay, Reginald Johnson said yes. And Margaret Williams?
No.
Okay. Got 4, so it passed. Okay, we're reading. Okay. Still,
Justice Byrd.
I thought two motion failed.
No, it passed.
passed.
So you just voted for the new motion, you're reading its entirety.
So moved. So I'm lost. I thought we were raising the motion. Head. Which one?
It was a substitute over Justice Hardin.
But substitute motion, Lloyd made.
The substitute motion passed. That's the one you said yes or no. I don't know if you said yes or no.
So I didn't realize that's what we were voting on. I thought we were voting
You
on
want to change your vote?
Even if he changed it, it's still gonna be 8, so I may as well start reading. Item 1, an appropriation ordinance to provide an appropriation to 1,000 county general elections being enacted by the Quorum Court of the County of Jefferson, State of Arkansas. Article 1, the county judge is hereby authorized to provide an appropriation for $100,000 to fund 1,000-109-3109 as detailed in the attachments. The county judge is authorized to approve the distribution outlined in the attachment. Article 3, the ordinance shall be in full force and effect from and after its passage and approval.
Move it out.
The motion has been made and second. All those in favor respond by saying aye. All opposed, like sign. Motion carries.
Item 2, a resolution to support and approve the application of the Southeast Volunteer Fire Department for the Rural Community Grant through the Arkansas Economic Development Commission, whereas the Southeast Volunteer Fire Department has demonstrated a commendable dedication to the provision of fire prevention and protection services to the citizens and property within Jefferson County, and whereas the department recognizes the need to enhance its capacity and effectiveness further to serve the community better, thus wishes to apply for the Rural Community Grant offered by the Arkansas Economic Development Commission, and whereas the said grant is a 50-50 matching grant with a total value of $15,000 requiring the department to match an equal amount either either in cash or through in-kind services, and whereas the Southeast Volunteer Fire Department Board has affirmed that it can responsibly match the amount of $15,000 through a combination of cash contributions and in-kind services, now therefore be it resolved by the Jefferson County Quorum Court as follows. The Quorum Court supports and approves the Southeast Volunteer Fire Department application for the Rural Community Grant offered by the Arkansas Economic Development Commission. The Quorum Court acknowledges and approves the department's commitment to match the $15,000 grant in kind and in cash and in-kind services. The board directs and authorizes all necessary actions to facilitate the application process and ensure the fulfillment of all requirements set forth by the commission. This resolution shall take effect immediately upon its passage and approval.
Next page,
That's just the signature
That was just the
page.
signature page. Yeah, signature page. Was there a motion? Second. Justice Carroll made a motion, second. The motion has been made and properly second. All those in favor respond by saying aye. Aye. All opposed, like sign. Motion carries.
Item 3.
Judge,
Yes,
may I sound that information as sponsor also?
yes, you may. Madam Secretary.
Item 3, an appropriation ordinance to transfer funds from Fund 3509 Justice Equitable Sharing Program Grant and provide an appropriation to 1,000 County General Sheriff, to 1805 Sales Tax Public Safety, and 1813 Adult Jail. Be it enacted by the Quorum Court of the County of Jefferson, State of Arkansas. Article 1, the county judge is now authorized to approve a transfer of $5,070 Fund 3509 Equitable Sharing Program Grant appropriate to 1,000 County General, 1805 Sales Tax Public Safety, and 1813 Adult Jail as detailed in the attachments. The county judge is authorized to approve the distribution outlined in the attachments. The county treasurer is authorized to transfer $1,316.21 from Fund 3509 to Fund 1,000, $292.50 from Fund 3509 to Fund 1805, and $3,461.29 from Fund 3509 to Fund 1813 as detailed in the attachments. The appropriation ordinance shall be in full force and effect from and after its passage and approval.
Motion has been made and properly second. All those in favor respond by saying aye. Aye. All opposed, like sign. Madam Secretary.
Item 4, an appropriation Item 4, an appropriation ordinance to transfer funds from the Amendment 79 Fund to the Reappraisal Fund and to transfer funds from the Assessor's Late Fee Fund to the Assessor's Fund. Be it enacted by the Quorum Court of the County of Jefferson, State of Arkansas, the county judge is authorized to provide an appropriation for $4,800 from the Amendment 79 Fund to the Reappraisal Fund and transfer $4,000 from the Assessor's Late Fee Fund to the assessors as detailed in the attachment. The county judge is authorized to approve the distribution outlined in the attachments. The county treasurer is authorized to transfer funds for $4,800 from the Amendment 79 Fund to the Reappraisal Fund, and also transfer $4,000 from the Assessor's Late Fee Fund to the Assessor's Fund as detailed in the attachment. The appropriation ordinance shall be in full force and effect from and after its passage and approval.
Motion has been made and properly second. All those in favor respond by saying aye. Aye. All opposed, like sign. Motion carries. Madam Secretary.
Item 5, an appropriation ordinance authorizing a one-time lumps.
That one failed, didn't it? Yeah.
Oh. The circuit clerk.
Oh.
Okay.
What's up with
So I'm on the elected official. Item 6,
I have a motion, Judge. Did I have a motion?
that was in committee.
Hold on.
Item 6.
I have a motion, Judge.
Oh.
That one failed in committee. It was item 5, item 5.
I'm on item 6 now.
Okay.
Which item failed?
5.
5 was about the leave time.
Yeah, it failed.
That's the one that failed?
Yeah, it failed, yes. So now she's on number 6. Justice Carroll.
Motion to table item 6. If I get a second, I'll speak to it.
Okay, there was a second?
Yes.
Okay, Justice Carroll?
I think with the discussion that we had concerning, this, item and the indication that there were some documents that verified, some of the things that was, said, the elected officials have done without this up until this point. Sounds like without knowing they had done without it. But, to be correct and, to eliminate all, questions of why now, why this, why that, I would ask the justices to table this and be on the agenda next, month with the supporting documents. Can I speak to that, Judge?
Yes, Justice Holcomb.
Yes, I think what we're talking about here is clerical mistake, something that can easily be corrected. And the people that hold those offices have earned that money, they deserve that money, and I think it's doing them an injustice for this court to hold that money up any further.
Thank you, Justice Holcomb. Any other comments? Okay, call for the vote. Call for the vote for the motion to table.
Adams. AG.
No.
Byrd.
No.
Carroll.
Yes.
Dumas.
No.
Franklin. Gaddy.
What are we doing? How to do that?
The back pay for the elected officials.
Oh, yes.
Is it a motion to suspend,
It's a motion to
suspend it or
table.
what?
It's a motion to table.
Motion to table it.
Motion to table it.
Justice Gaddy, it's a motion to table the,
Oh, no.
Hardin.
no.
Holcomb.
No.
Jackson. Patricia Johnson.
No.
Reginald Johnson.
No.
Margaret Williams.
No.
Okay, so we are on item number 6, is it failed? An appropriation ordinance to provide an appropriation to pay back.
So Judge, did we move, did we move?
Justice, wait until you're recognized. The motion to table failed. Now we're going to the original.
Right. We gotta read it
reading.
again. Right.
Okay.
We need a motion.
Madam Secretary.
I made, well, there was already a motion and then there was a secondary motion, I
I
think.
made the table before a motion was made.
Oh, okay, whatever.
Do we need to read it again? Is that what we have to do?
Yes, has to be read again.
Need to read it.
She
doesn't need a,
Madam Secretary, now you read.
You just need a motion to pass. That's all you need, a motion to pass and a second.
It's already been read.
It has not been read. He
Oh,
did
okay.
before the reading. So, Madam Secretary, proceed on.
An appropriation ordinance to provide an appropriation to pay back funds to certain elected officials, be it enacted by the Quorum Court of the County of Jefferson, State of Arkansas, whereas an administrative error occurred in the calculation and disbursement of the elected official salaries leading to an underpayment for 2022 through 2023, and whereas it has been determined that the amount due to rectify this error and to provide full and correct payment to the elected officials for the said period amounts to a total of $30,494.63, and whereas it is deemed necessary and in the best interest of Jefferson County to correct this error and provide the due payment to the elected officials, assessor, county clerk, circuit clerk, tax collector, treasurer, and sheriff. Now and therefore be it ordained by the Quorum Court of the County of Jefferson, State of Arkansas, as follows: the sum of $30,494.63 is hereby appropriated to rectify the payment error and disperse the corrected salaries to the elected officials for 2022 through 2023. The county judge is authorized to approve the distribution outlined in the attachments. This ordinance shall take effect immediately upon passage and approval.
Move for the adoption.
Motion has been made and properly second. All in favor respond by saying aye.
Aye.
All opposed, like sign. Motion carries. Madam Secretary.
Item 7, resolution, be it resolved by the Quorum Court of the County of Jefferson, State of Arkansas, that a resolution authorizing the county judge of Jefferson County to apply for a grant on behalf of the Jefferson County Circuit Clerk, whereas Jefferson County is applying for a grant through the Association of Arkansas Counties to scan county land records to a fully integrated land records management software system, and whereas the proposed scanning will also give an updated public search product for our courthouse search stations, as well as remote access for those who wish to search from home or their office, and whereas the purpose to preserve the history of our future generations, and whereas the Quorum Court of Jefferson County, Arkansas recognizes the need for this project, concurs its importance, understands there will be no cost to the county for this grant, and wholeheartedly supports the effort to proceed with this project. Now therefore be it resolved that the county judge of Jefferson County is hereby authorized to apply a grant from the Association of Arkansas Counties for the purpose of securing grant funds in the amount of $125,000 to aid and assist the proposed project described herein, and the county judge is further authorized to administer the grant funds for the said project.
Move for the adoption.
Motion has been made and properly second. All those in favor respond by saying aye.
Aye.
All opposed, like sign. Motion carries. Before adjournment, there's a couple of things I'd like to discuss with the Quorum Court. We are vastly running out of space for records. The county clerk, the circuit clerk, the treasurer, and who else? Oh, and district court. We've run out of room, and records are in dire straits of being destroyed by the conditions that in the buildings that they're in, and so we are seeking space for those records. So I will be bringing to the court a lease agreement with Leland Stice. Has a building which is the old Coca-Cola building, so that we can try to provide a area and space for records to be moved. We are going to try to, from I think this point on, I think some departments are already digitized. Some departments are already digitizing from now forward, but we have to retain those records that's in the past. So we'll be bringing that to the court. Also, we will have a special meeting next Monday, 5:30, to bring those items that were vetoed to make them right by reading those items. So that'll be next Monday at 5:30. Next Monday at 5:30, which will be the fourth. What was it? was the 14th? Okay, yeah, next Monday on the 14th at 5:30. Also, okay, that's all I have. I have an entertained motion to adjourn.
Can I make 2 points?
Justice Carroll?
One being personal. I recently got a phone call from some unsubscribed number. When I tried to call it back, it said the number was unsubscribed. You all may not know, but I lost a brother in the Vietnam conflict. He sustained injuries in the conflict that caused him to have infield amputations. And he was flown back to Texas, and he later passed in Texas. Well, I had been seeking some understanding about the Wounded Warrior Project so that I could become a participant and encourage others. I don't know who this person was that called me about my brother and the fact that he's not on the monument over at the Veterans Building, and the judge and I have discussed that. But I don't know who it was that called me from an unsubscribed number that I could not call them back. But I would hope that we have not deteriorated to the point in our conversations and interaction, even though when we don't agree, and sometimes we really don't agree, that people would lower themselves to that standard. The other thing, Judge, is that
Can I speak? I don't mean to interrupt. Can I speak to that as far as your brother? I am in talks with Pine Bluff Glass to even though your brother was not on the register for whatever reason or not, we are working to rectify that so that the name can be added on the memorial wall. So if you would be patient with us to get that done, we are working on that. I've already talked with Ms. Goodlow.
Good, great.
So we are already working on that.
Thank you, Judge. Thank you. The other point is that the law does say that we should take action at the next meeting after you notify us that you have vetoed legislation, which would have been this meeting, in that we didn't do it. And then there's a special meeting coming up next week to do it. I'm thinking that the law says if we don't take action at the next meeting, that those things have to be reintroduced. And so I just wanted to share that out. I don't know how you want to proceed with the meeting, but I think the law stipulates that since we did not take any action here, then our next action is to reintroduce those things.
That's correct. Thank you, Justice Carroll. If nothing else holds our attention, I entertain a motion to adjourn. All right. Meeting adjourned.
See you guys later.
Baseball umpire, but that's
Keep coming back.
as long as he tells me.
Got a few things right. Sounds like Monday night.
You still have a copy of the procedure.
Well, it's like 2023-5.
But what they're complaining about is the judge providing the instructions not.
It's that way. It's not.